Start. Para. Appellant, original defendant numbers 2 to 5, has preferred this appeal being aggrieved by the order passed below Exhibit number 5, dated 24/6/2011 by 4th Civil Judge, Senior Division, Thane, and Link Court, Bhiwandi, in Special CS number 393/2011. Henceforth, parties shall be referred as plaintiff and defendant for sake of convenience. Para. According to defendants, the plaintiff had filed the suit for declaration of ownership in respect of 800 square meters NA land and restraining the defendants from interfering with the possession of plaintiff over suit property. The learned trial court allowed the application Exhibit number 5 and restrained the defendants from entering in respect of suit property, that is serial number 21/2, to the extent of 800 square meter till the decision of the suit. According to plaintiffs, they are the owners of survey number 21/5 and survey number 21/2. They purchased this property from Penta Tech Engineering on 23/10/2009, and said Penta Tech Engineering also purchased the land bearing survey number 21/2 from Sri Dwarkadas by sale deed dated 29/2/1996. Thus, plaintiffs become owner of survey number 21/5 and 21/2. Injunction is granted restraining defendants from interfering plaintiffs' peaceful possession over suit property. Para. As far as this citation is concerned, the fact of the present case are concerned. Plaintiffs are claiming ownership in respect of suit, the suit property, on the basis of sale deed and revenue record in their favor. If they succeed in establishing their claim, that owner of property has every right to protest his property by seeking relief of temporary injunction. No doubt, at the interim stage, final relief cannot be granted, but the applicability of this citation will depend upon in what manner plaintiffs demonstrated their case before this court for entitlement of injunction, and bearing in mind the principles laid down in these two authorities, this court will certainly ascertain whether the relief which will not be granted, that should not be relief of final relief. Here, the main relief of plaintiff is for declaration of ownership, and consequently he prayed for relief of perpetual and temporary injunction. Para. Now, the plaintiffs and defendants are rivalry claim their right, title and interest in respect of suit property. If case of plaintiff is taken into consideration, the learned trial judge has taken into consideration about sale deed executed by Penta Tech Engineering in favor of plaintiffs, and from revenue record it appears that on 1/2/2010 mutation entry took place in the name of predecessor of plaintiff number 1 is not in respect of entire area as shown in sale deed of plot number 1 and 2, but other revenue documents and its area mentioned in yards and meter shows that revenue proceeding is going on before revenue authority. The learned trial judge has observed that in the sale deed executed by defendant number 2 to 5 in favor of defendant number 1, the southern side boundary is shown as property of Penta Tech Engineering. The learned trial judge has taken into consideration sale deed dated 31/5/1996 and 12/12/1968, which prima facie shows that defendant numbers 2 to 5 were never in possession of 800 square meter land out of survey number 21/2. I have gone through all the documents and citation according to me. The learned trial judge has considered the possession of plaintiff over the suit property on the basis of sale deed and revenue record, and has observed by learned trial judge tribal issue are involved and suit is for declaration and ownership, and whatever objection raised in respect of locus standi of Vasanta for execution of sale deed in favor of predecessor of title of the defendant can also be decided in the trial itself. This being a interim stage in the present suit, tribal issues are involved, and unless and until parties laid their evidence before trial court, the final conclusion about ownership and possession cannot be drawn at this stage. But prima facie plaintiff appears to be in possession of the property, and the learned judge has rightly appreciated the matter in dispute. Therefore, I do not find any reason to interfere in the discretion used by the learned trial court. Stop.